Assalamualaikum warahmatullahi wabarakatuh. So welcome back to our lecture. We are still discussing the topic mistake. Okay, we haven't completed the lecture on this topic. So in the previous lecture, we have covered up to mistake done by both parties. Okay, we discussed about different circumstances in which a mistake could be done or could be committed by both parties. Okay, so for the continuation for today, basically we're going to cover mistake by one party, okay, under Contracts Act 1950, and as well as shortly about mistake with regards to law. And then we are going to have a look at some of the decided cases from Malaysia, okay, local cases, which was, to illustrate, okay, the application of the rule. And then the last part of our topic for today, okay, lecture for today is about unilateral mistake, okay, but specifically discussed under common law, all right, especially with regards to contracting party. We are going to discuss it later. Okay, let's have a look at the slide here. Okay, mistake by one party, obviously it is called as unilateral mistake. Okay, uni indicates one. Okay, only one party is mistaken. So basically, one party is mistaken and the other party actually is aware. Okay, knows or must be taken to know of the mistake. So meaning that here, if there are two parties, of course there are two parties, okay, of the contract. So one of them is aware of the mistake committed by the other party, is aware of the true or the facts, okay, of the case here. Okay, so but what's the rule? Okay, what's the legal position? Okay, on the mistake done by one party here. So a mistake made by one party, okay, is not an operative mistake. So it's not really recognized, okay, in the eyes of law as a vitiating factor, okay, to affect the validity of the contract. Having said so, meaning that here the contract remains valid. Okay, we have a look at section 23, okay, in which you can actually see the term, okay, the word used is not voidable, okay. All right, and then we don't have any specific section, okay, which interprets, okay, the word not voidable here. Okay, it's quite ambiguous in that sense, okay. So the query here is, all right, whether the contract is valid or void. What's the meaning of not voidable here? So from the case law, from the analysis by the authors, okay, legal juries, okay, so the better view is that, okay, the contract is valid, okay, all right. So for why is that so? Okay, why is unilateral mistake not void, okay, under Contracts Act, okay, as opposed to mistake committed by both parties, okay? Because if it is common or mutual mistake, then usually the contract is void, okay, even it is void ab initio at common law, all right. But why is unilateral mistake is not void, okay, as far as Contracts Act is concerned? There must be a reason, okay, of that. Okay, so one of the reason or rationale behind the rule here, okay, is basically to protect bona fide purchaser for value without notice. Okay, whenever there is any further transaction, okay, involving purchase usually, and the purchaser pays, okay, for the transaction, okay, and then the purchaser is not aware of the previous transaction which is affected by mistake. So basically, the contract remains valid. Okay. Operative mistake, okay, will render the agreement void. Okay, if the mistake is considered as operative, okay, it will make the contract becomes void, not enforceable. Okay, so the effect is that the subsequent bona fide purchaser will have no title to the goods. Okay, let's say the earlier transaction was void, then the title cannot be passed on, okay, to the subsequent purchaser. Okay, alright. So that's why whenever it involves unilateral mistake, then the contract is still considered valid. Okay, and the next party, subsequent purchaser, has the right operate. Okay, can insist on the legal title for the subject matter. Okay, all right. So and then if it is not valid, okay, usually the subsequent, bona fide purchaser would be liable for conversion. So we don't want that to happen. We want to protect this bona fide purchaser who has paid some value and then who is not aware of the earlier transaction which is affected by mistake here. Okay, all right. So this is I give the definition. Okay, the meaning of conversion. Actually, you are going to learn in your law of thoughts too. Okay, yes, I'm teaching thoughts too as well. Okay, we move further. Okay, actually we move backwards. Okay, just now we discussed about section 23. Now we come back to section 22. Okay, what does it say? Okay, refer to your Contracts Act here. So section 22, it says that it's very short, okay? Straightforward here. A contract is not voidable, okay, because it was caused by a mistake as to any law enforced in Malaysia. But the mistake as to law, okay, not enforced in Malaysia has the same effects as a mistake of fact. So there are two parts here. Okay, all right. The first part, okay, until the word Malaysia, okay, all right. And the second part is but a mistake as to law, okay, all right. So basically, generally, okay, mistake with regards to Malaysian law, local law, okay, the contract is valid. Okay, all right. Again, they use the word, the term not voidable, similar to the term used under section 23. Okay, all right. Okay, what if the mistake with regards to foreign law? Okay, here. So if it is foreign law, okay, meaning that it's not Malaysian law, okay, it will be treated, okay, as a matter of fact, okay, whether it is essential to the agreement or not. So if it is yes, then we cross refer to section 21. Okay, we apply the similar rule. Okay, all right. Okay, so it's quite straightforward. Okay, you can also read illustration illustration to section 22. There's just one illustration. Just a simple one here, all right. A and B make a contract grounded, okay, on the erroneous belief that a particular debt is barred by limitation. Okay, so the contract is not voidable. So here limitation limitation law, okay, limitation rule, usually it is governed by Limitation Act. So everyone is supposed to know the law. What if you don't know? Okay, you have to ask for legal advice, okay, legal opinion from lawyers, okay, solicitors. Okay, before we go to English principle of English rule, okay, on unilateral mistake. So let's have a look at some of the local cases on mistake, okay, which was decided in Malaysia. So the first case for today is Fu Liang Sin and another, okay, and Ng Chun Lin, okay, and another reported in MLJ 206 here. So we have the second plaintiff, okay, as the tenant of shop house number 9. Take note of the number, okay, very important here. And we have the first defendant, okay, who was the tenant of shop house number 11. And number 11 is actually just next to number 9, adjoining. Okay, usually it's odd number, okay, 9, 11, 13. Okay, all right. So, and then this both number 9 and number 11 of shop houses here, okay, was originally owned by this company, okay, Hang Chun, okay, Sunamberhat, Hong Chun, I'm not sure how to pronounce it, but I think Hang Chun, Sunamberhat, and subsequently sold to the parties. So the owner, okay, wanted to sell the shop house, the premise here, okay. All right. And then later, okay, that's the dispute. Okay, plaintiffs, okay, who was the plaintiff again? Okay, plaintiff was the tenant of shop house number 9. Okay, so plaintiff number 9. They claim that, both of them, two of them, okay, claim that a mutual mistake had occurred, okay, in the conveyance of the two shop houses, so resulting in defendants becoming the registered proprietors of shop house number 9. Remember, plaintiff was the tenant of number 9, okay, which was purchased by them, so they wanted to purchase number 9, but eventually, when the sale was completed, okay, number 9 was sold to the defendant rather than the plaintiff, okay, and the plaintiff becoming the registered proprietor of shop house number 11. So plaintiff didn't want, okay, number 11. They wanted number 9, okay, but defendant also wanted number 9. So defendant denied that there was such a mistake. Said, yeah, I wanted to buy this one, so I'm the correct owner. Okay, nothing wrong with the conveyance or the document here. Okay, so this on the trial court level here, okay, the learned judge, okay, having been satisfied that there was a mutual mistake, so the court agreed with the contention, okay, by the plaintiff, Okay, there was a mutual mistake. That's what the judge said. Okay, decided. So the judge made an order, okay, directing, okay, the registrar or land administrator to make necessary rectification. Okay, please do rectification. Okay, please rectify the registered document of title. We call it grant. Okay. As well as IDT. So please do necessary amendment, okay, rectification, correction to register, okay, the title as well as the grant, okay, the physical title, okay, the issued one. So meaning that here plaintiff won it, okay, plaintiff got the number 9. So defendants are not happy, obviously. So defendants appeal against the decision of the learned judge here. Okay, and then at the appeal stage here, the defendant won the case. Okay, so the appeal was allowed. Okay, why? Okay, what's the reason here? Okay, sale and purchase agreement, the SMP, SPA here. Okay, the charge and the schedule to the annexure. Okay, there too. So the court referred to all this document. Okay, and the finding was that, okay, all the documents were consistent, okay, with the title. Okay, HSD. That's the title number. Okay, that was purchased by the defendant. Okay. But the problem arises because why? Okay, in the SPA, the shop house number was wrongly described as number 11 when it should be number 9. So the confusion is because of the wrong quotation, okay, in the SPA. The title was correct. Okay. So the judge said that, well, the only document that mentioned the shop house number, okay. Okay, all right. So basically, SPA, okay, was the only document that mentioned the shop house number. As far as the title was concerned, okay, nothing wrong with the title. So that no need to rectify anything. Okay, all right. So shop house number clearly could not prevail over the suratan hak milik sementara, the grant, okay, and the PT number in the documents, okay, which was under land office, okay, and then shop house number 9, number 11, okay, was the number given by the local authority for the purpose of assessment, okay, to collect rent, basically quit rent, okay. So mean that here the confusion is by the local authority, okay, not by the land office. So nothing is wrong, okay, no need to rectify whatsoever, okay. All right, and then after all, the court said, well, shop house was part of the land. Okay? If you bought that land, you get the shop house as well. Okay, it couldn't be sold without the land. So after all, the shop house is immovable property. Okay, so it was the land that was sold with the shop house standing on it. Okay, you are buying the land together with the shop house. It's not that you are buying the shop house together with the land. Okay, here, all right. So what happened was that the plaintiff, the tenant number 9, actually number is number 11, okay, the correct one. Plaintiff might have been mistaken into thinking that they were purchasing shop house number 9, okay. So basically, it was, if that was the case, okay, that was their mistake. So obviously, it was not a mutual mistake, okay. So plaintiff could be mistaken, but defendant were not under whatever mistake here. They know they are buying that particular land, okay, together with the shop house on it, okay, attached to it. So that's basically the case of Fu Lianxin and Ng Chunlian. So at the trial court stage, okay, the court agreed there was mutual mistake, but later where on appeal, okay, actually it's just unilateral mistake. So the contract is still valid. So no need to rectify, okay, to do any rectification. Okay, let's move to the second case, all right. This is a landmark case. You can find this case in the textbook, obviously. Okay, the case is Ho Weng On and another at Bin Dev Syndrome Berhad, okay, 207. So it involves sale and purchase of certain property here, all right, house, I think. So by a pro forma sale and purchase agreement, okay, dated 6 February 2006, okay, take note of the date there, 6 February 2006. Plaintiff agreed to purchase from defendant. Okay, so plaintiff was the purchaser, were the purchaser. Okay, another. So we have more than one here, right? From defendant, a property at the price of 300 to 21,000 ringgit Malaysia. Okay, and then they signed a pro forma agreement, and then they paid the deposit. Okay, I mean to conclude the whole agreement, even though the full documentation needs certain period of time. Okay, all right. And then pursuant to clause 2 of the pro forma that they have signed, okay, so the defendant was supposed, I mean the seller, the vendor, okay, the developer actually, okay, the defendant was supposed to forward the official sale and purchase agreement to the plaintiff, okay, for their execution. So they need to sign the proper document, all right. but defendant failed to do so. Nothing. So no agreement whatsoever, okay, was forwarded to them, okay, to the plaintiff. So now because of that, now plaintiff commenced this action to for specific performance, okay, to compel, okay, the other party, defendant, to proceed with the contract. Basically, okay, sale and purchase contract here, sale and purchase agreement. So after filing this action, okay, it was discovered that actually the property that they had bought, okay, had actually been sold to another person, okay. The name is Lai Chui Peng, okay. And take note of the date, okay, 23rd February 2005, okay. When did they sign the pro forma? Okay, 6 February 2006, a year later, okay, more or less, okay, a year later, okay. Alright, so now there are, as if, okay, you are selling the property again, okay, double actually, okay, double transaction. So if you read further, okay, there were a number of issues, okay, and then the relevant one. So we just focus on the relevant issue to which is pertinent to our topic here, okay. One of the issues raised, okay, in because of the argument, okay, in the court. So it was stated that even if there was a binding agreement, okay, the agreement is void. Okay, this is I think argument on the part of the developer. Okay, they said, well, even though we have a sale and pro forma, okay, we sign pro forma, but our agreement is void, okay, on the grounds of common mistake, okay, because both parties were mistaken, okay, as to the availability of the said property for sale at the time of contract. Meaning that here, when we entered into, when we signed pro forma, okay, basically the house, the property was no longer available, okay, to be conveyed, okay, to the new buyer, okay, because it has been sold off earlier, okay, a year before. Okay, and then so basically remember, okay, the plaintiff was the one who filed this suit, all right. So the court said, well, we allow your appeal, so we agreed with your argument, okay, and then the court quoted, okay, specifically section 21 and highlighted the word both of the parties, okay, all right. So from the overall, okay, the whole facts, okay, of the case here, okay, it is very clear that it cannot be said that both of the parties were mistaken, okay, for the simple reason that the only party who had the exclusive knowledge that the property has already been sold to a third party must be the defendant developer. Meaning that here, is it mistake by both parties or is it a mistake by one party here? Obviously, developer is supposed to know whether the property is still available for sale or not here. Okay, so only one party is mistaken, not both. All right. So the plaintiff purchaser must be taken to have no knowledge. So plaintiff, the purchaser doesn't know. Okay, if they know, of course, they won't proceed with the signing of pro forma and payment of the deposit, the booking. Okay, all right. So they would have not purchased the property in the first place if they know it's no longer available. Okay, but the developer is supposed to know. Okay, all right. The defendant should have known the property had already been sold to third party. Okay, especially the sale had taken place more than a year ago. It's not last month. It's not last 2-3 months. It's a year ago. Okay, meaning that last year. Okay, previous year. And then purchaser, plaintiff, okay, would not have known. Okay, so as far as the case was concerned, okay, defendant cannot rely on the doctrine of common mistake. Because why? The mistake was only a unilateral mistake. And then the mistake was a direct result of the defendant's own wrongdoing. So you can't really use that as your defense. Okay, remember the argument was put forward by the defendant. Said, well, actually both of us were mistaken. No, okay, you are the one who was at mistake. That's what the court said in this case, okay? All right, so are you okay with how went on? So again, even though argument actually revolved around section 21, but eventually it's not, okay? The mistake was on the part of one party only. It's unilateral, and the one who argued that it was common mistake, okay, rather than mutual mistake, rather than unilateral, okay? Actually, it was unilateral. That's the finding by the court. Okay. Another case on mistake here, Hamzah bin Abdul Majid and Khairuddin bin Zainal. Okay, this is MLGR reported. Okay, 2017 is quite recent. Okay, so Okay, we have the plaintiff. Okay, we also have administrator involved here. Okay, all right. So defendant was the other joint administrator. So basically, it's between the plaintiff, okay, who wanted to buy the property, and then suing the administrator. Okay, plaintiff entered into sale and purchase agreement, okay, with the first administrator of the estate of Wan Haji Omar bin Lani. Okay, administrator is the one who administer the property of the deceased, okay, after the death lah. Okay, alright. And then usually the deceased didn't leave any will. If they leave a will, then we call, I mean, the term used is executor, okay, rather than administrator. So for this case, there were two administrator, okay, or we use the term joint administrator, okay, all right. So plaintiff claim, okay, plaintiff is the one who purchased the property, okay, plaintiff claimed that the agreement between him and the first administrator, okay, actually the owner had died, okay, and then when the case was brought to the court, the first administrator also died, okay, all right, this is already both of them. So now plaintiff said, well, when I signed the agreement, I have signed the agreement, okay, property was purchased by me and it's valid and enforceable. But defendant disagreed, okay, so defendant was the other joint administrator filed a counterclaim that the SPA was invalid and be cancelled. No, okay, because why? I'm also the joint administrator, that's what defendant said, okay, and then it was done without my consent here, okay. Defendant, the joint administrator, okay, claimed that the original title to the subject land presently in the custody of the plaintiff to be returned to the defendant. Please return it to me, because why? The transaction was invalid, okay. And then compensation received from the government, okay, for acquisition of the land currently held by solicitors, okay, as stakeholder, be ordered to be released to the defendant. And then whatever money you receive, okay, because as if you are the owner of the property, okay, you receive compensation from government for a compulsory acquisition of the land. So please return the money to me, okay, the joint administrator asking for the return of the compensation, okay, paid by the government. There were two claims here, right, by the defendant. So when the court examined, okay, all the facts, okay, surrounding the case here, okay, so this is the conclusion, okay, from the overall evidence here, okay, actually, all right, plaintiff, okay, was aware that there were two administrators appointed to administer the deceased estate. When you sign the agreement, you know, okay, there were two administrators, whereas you signed it only with one administrator, okay, but still, okay, he proceeded to enter into the SPA, sale purchase agreement, with only one of the administrator, okay, despite there being serious doubt as to the competency and capacity. Meaning that here, they need two administrators because maybe it has something to do with competency. I mean, if one, then it's not competent. Okay, whatever agreement must be signed by both administrator. Okay, all right. So even though you have doubts, okay, about the first administrator to act alone, okay, basically the deceased, he could not act alone. Okay, all right. So, and then defendant counsel argument here, okay, even if the parties were under the mistaken belief or impression that he was competent, okay, the contract would remain void and unenforceable by virtue of section 21, okay, because both of them were under a mistake, okay, with regards to the competency of the first administrator, okay, meaning that here when they sign, okay, both of them were not sure, mistaken, okay, about the competency. So obviously the contract was void. Okay, I mean, it was an operative mistake. So again, this contract emphasize or illustrate to, this case illustrate to us application of section 21. Okay, all right, which is important, even though the case was unreported. Okay, we also have some other cases actually for the topic mistake. You can read, okay, the full report of the case of Menta Construction and Lestari Puchong. It involves some agreement, the Global Settlement Agreement. Okay, you can GSA. And then for this case of Sun Li Huat Palm Oil Mills from Berhad and Stable Winds from Berhad, it is important because it discusses about mistake of law, okay, which is section 22. So you can read on your own, okay, these two cases, all right. Actually I plan to proceed, but then I think it has been pretty long, the lecture. So I stop here. So I'll continue with the part 4 of the, final part of the lecture for the topic mistake after this. Okay, so stop for a while. Okay, all right, that's all. Okay, I'll see you in the final part of the lecture for the topic mistake. Okay, Assalamualaikum warahmatullahi wabarakatuh.